So somebody was kind enough to put up a couple printouts from Westlaw relevant to Texas on Bunny Boot's Discord server. From that, it it wasn't real. I mean, this is one of those cases where you're gonna have to get an actual lawyer or legal researcher in a law library in Texas to get to really dig down and find the relevant information. I did talk to Mr. Hemming, and he agreed very graciously, since he is in Texas, to stop by a local law library and shepherdize some case law for me so that maybe I can give a reasonable analysis of the situation. So thank you very much, Mr. Hemming. That said, back to what I do have right now. This is Gibson v. the State of Texas. In Gibson v. the State of Texas, the police were responding to a armed robbery call or a robbery call from a Walmart. They arrived at the Walmart and they stopped a Toyota that was at rest in front of a stop sign within the parking lot. The officer blocked him in, basically. And so at that point, that Toyota and all the occupants in it were detained. Is it a valid detention? Well, the cop got out, and almost immediately one of the guys said, "Oh, we just saw a robbery." So now it is a detention that is of witnesses. Interesting. So the analysis, this is Texas, and they're referencing a U.S. Supreme Court case, Illinois v. Lidster. But the Texas analysis of Illinois v. Lidster is the appropriate analysis because we're looking at the Fifth Circuit. Well, actually, we're looking at Texas's interpretation of the Fourth Amendment analysis provided in Lidster as applied to Texas law. So this is actually the Texas Court of Appeals. This is a Texas state court. So it's actually on point with what we're looking for. The United States Supreme Court observed that the stop's primary law enforcement purpose was not to determine whether a vehicle's occupants were committing a crime, but to ask vehicle occupants as members of the public for their help in providing information about a crime in all likelihood committed by others. The court went on to state that such stops are not automatically or even presumptively constitutional. Rather, the reasonableness, I told you it'd be down to a reasonable test, a Fourth Amendment reasonableness test, and hence constitutionality must be judged on the basis of the individual circumstances. In judging the reasonableness of the stop in question, the court looked to the gravity of the public concerns served by the seizure, the degree to which the seizure advanced the public interest, and the severity of the interference with individual liberty. The court then held that the stop was reasonable, setting forth the following reasons. Number one, the stop's objective was to help find the perpetrator of a specific and known crime, not of unknown crimes of a general sort. Number two, the relevant public concern was grave. Number three, the stop advanced this grave public concern to a significant degree. And four, the police appropriately tailored their checkpoint stops to fit important criminal investigatory needs. And five, the stops interfered only minimally with the liberty of the sort the Fourth Amendment seeks to protect. Now, how would this apply in the situation we saw at Leon Valley? Was it a specific and known crime? The police knew of specific threats. So these are specific and known crimes. And they are looking to find the perpetrators of them and or the people who are aiding and abetting those perpetrators. Number two, the relevant public concern was grave. You're going to say, oh, they're just threatening cops. Well, believe it or not, there is a... the public does seem to be very interested in the safety of cops. If you look at legislation, there are aggravating factors in a lot of laws where if you assault a normal person, you'll get, a third-degree felony. But if you assault a cop, that's a second-degree felony because, he's a cop. So it is a public concern to have police officers being threatened for carrying out their official duties. And that public concern, especially if you're threatening the families of these law enforcement officers, is grave. I'm I am almost 100% certain that a court will find that threats to the health, lives, and safety of police officers and their family would be a grave public concern. Number 3, the stop has to advance this grave public concern to a significant degree. By detaining these people, they can determine lots and lots of things. They could determine the real names of these people versus the screen names. They could determine which person has which phone, which stream belongs to which person. They can figure out which account they need to, I guess, subpoena deuces tecum, I guess. I don't know what it would be. But they would need to contact YouTube to get more information about IP addresses and things like that for who these various commenters are, or Twitch or whoever. You know, I don't know if the police know the full extent to which these various Streamlabs and things were all connected. So it is going to advance the police in determining or solving this grave public concern. Number 4, the police have to appropriately tailor their checkpoint stops to fit the important criminal investigatory needs. They brought everybody together who was filming. I mean, they laid that trap perfectly to gather the interest of the people who are out there filming and streaming in the area. So there you go. And number 4, the stops interfered only minimally with the liberty of the sort the Fourth Amendment seeks to protect. I'm not sure entirely how long everybody was detained, but, you know, considering the number of people there, I'm sure that they would probably, it'd be a balancing test. First of all, let me just start there. It's going to be a balancing test. The more grave the other factors are, the less grave, or the more they can infringe upon the liberties. And I say this because this is the way the courts think. This is the way the Supreme Courts do it. If they have multiple factors, it's going to be a balancing test to determine, you know, if it's an enormous, like if there's a thermonuclear device in the middle of the city, and, you know, that is such a grave public concern that I'm sure the police would be justified in a lot of things that they wouldn't be justified over a threat to an officer's family. And the police will be entitled to do things that, over a concern like a threat to an officer's family, that they wouldn't be able to do over something like figuring out which one of the auditors pissed in the corner of the building. You know what I mean? So, judging from this, I'm going to go ahead and say that I don't know if these, I know some of them were arrested, or at least said they were arrested. I don't know how it's all going to shake out because I don't have all the evidence or all the case law. But if it was, well, these are the elements that they're going to weigh on any determination of whether or not these detentions and or arrests were reasonable. So do with this as you will. This is your friendly local statist signing off.